Ohio versus Clark Williams, case number 24 CR 1313. Defendant is present, represented by defense counsel. We're here today for the sentencing in this matter. Defendant previously pled.
A second-degree felony for felonious assault is serious. This isn't a bar fight gone wrong. This is legally recognized as causing serious physical harm. In many states, that alone can carry multiple years in prison. So the defense already knows they're playing damage control, not defense.
Guilty to the indictment, felonious assault, felony of the second degree. Pre-sentence investigation and report have been completed since then.
And no victim impact statement received from anybody?
No statements have been submitted. I have spoken to them, which I can address later.
All right. Mr. Langmack?
Thank you, Your Honor. Obviously, this was a tragic situation. That there was no good outcome for anybody, especially the victim in this.
This is where the tone shifts. The defense is trying to humanize the situation, calling it tragic, emphasizing it wasn't intentional. But here's the problem. When the victim has permanent medical damage, courts tend to focus less on intent and more on impact. And seizures? That's life-altering.
We understand that he still suffers from medical issues and is prone to seizure, as we've been told. I know Mr. Williams is not his intent. It's never the intent, though. When people do things like this. It's a situation that got out of hand. Each side, groups of people arguing with each other, bad blood in between, and it escalated quickly. Unfortunately, somebody always, at least one person always gets hurt in these, and several people have to pay for that afterwards. Mr. Williams is one of those. He and his uncle both struck Mr. White and caused this damage to him. That is unfortunate, and I know Mr. Williams could go back and not do that, not take that swing. He would do that. He would rather not be sitting in front of you here today with this hanging over his head. Unfortunately, that's where we are. We would ask that Your Honor take into consideration that although Mr. Williams was the first to hit, the uncle was the second to hit, whether or not that's, one was worse, better.
This is a key defense strategy, shared blame. If both parties are equally responsible, maybe the sentence should be lighter, right? But here's the catch. Courts often look at who started it. And being the first to hit can carry a lot more weight than the defense would like. What do you think? Should both get equal punishment? Or does the first punch change everything?
Exact same, I don't know. I don't know, Your Honor. But I think they are equally culpable in this. I don't think the majority of damage can be attributed to anybody. They have to share equally in the blame for this, for the harm that they've caused Mr. White. We know there are factors that went into deciding whether or not to offer a lesser count to Mr. Williams. He didn't get that. He pled to the F2. He did that willingly, and he had no issues. He understood. However, we would ask that in sentencing, you take into consideration the fact that his co-defendant looks at a maximum of 3 years. We would ask that that be considered in the number that you come up with for Mr. Williams. He is not proud of what he did. He's not happy about how he reacted that day. He's not happy about a lot of things that happened that day. But we just want you to consider the outcomes for each of the Mr. Williams and his uncle and the actions that they both shared in that afternoon. Thank you.
And that right there is a moment people overlook. He chooses not to speak. Sometimes staying silent is strategic, but other times judges want to hear remorse directly. A simple apology can sometimes influence sentencing. Do you think staying silent helped him or hurt him here?
Mr. Williams, what do you want to tell me before I impose sentence?
Nothing, Your Honor.
Mr. Gretzky?
State recommends 4 years served consecutive to the defendant's current prison sentence. There is a co-defendant in this case. The victim was not involved in any previous arguments that the defendant had with the family of the woman who was pregnant with his child. And it had been a long history of arguments and animosity between the family and the defendant, which came to a head on this day. The victim was really stepping forward to protect his sister. He did not have any involvement in this fight. He stepped forward and was facing the co-defendant. The defendant sucker punched him to the side of the head, and there were multiple witnesses that
This is the turning point. The word sucker punched changes everything legally and emotionally. That implies no warning, no fair fight, just a sudden, dangerous strike. Combine that with severe injuries, and now the prosecution's argument becomes much stronger. At this point, you can almost feel where the sentence is heading.
said that knocked the victim out cold even before he hit the ground. He was going straight for the ground. So there's a difference in the conduct between the defendant and co-defendant here. And
What did the co-defendant do?
the defendant punched him as he was going down.
Right. What did the co-defendant do?
The defendant punched the victim first.
Right.
Knocked him out cold. The co-defendant punched the victim as he was going down.
Okay.
The victim suffered serious physical harm, as has been stated multiple times, and I've spoken to him throughout this case. This has completely changed his life. He has to be on medications for the rest of his life, has lost ability to do things on the left side of his body. He was hospitalized for 3 months, time he can never get back, and he, in a as far as a mental health status, it's impacted his ability to go places and work because he has to be on these medications. He's prone to have a seizure at any time. So it's of course affected him emotionally and mentally. And I agree, it never should have happened, and it wouldn't have happened if it wasn't for the defendant.
The defendant showed up at this shower uninvited, correct?
He was invited the night before.
The night before, okay.
Yes.
Showed up with somebody else, right, who had
His-
a weapon?
Yes, there was someone in the vehicle with a weapon.
And it seems to me, from what I read in the pre-sentence report, the moment that the defendant and whoever he showed up with showed up, the argument ensued. Is that accurate?
The argument started at the end of the event in the parking lot. So it was in the parking lot, but at the end of the event.
Okay. And this incident occurred May 7th of 23. Is that right?
Yes, Your Honor.
Do you know what the indictment case was filed toward the end of 24? Do you know what the reason for that delay?
The greatest delay was this case was indicted with the co-defendant's case. Co-defendant's case came over as a bind over. It did take about a year for charges to be filed, and I believe there were, I cannot say for certain actually that there was a warrant, but it was my decision to indict them together when I indicted the co-defendant.
All right. In the meantime, so May of 23, in May of 24, there's the incident in Cuyahoga County which led to the conviction of Mr. Williams for attempted murder. So a year plus after this incident. Correct?
Yes, Your Honor.
Okay. For which he's now serving a 10 to 13 year sentence, is that right?
Yes.
All All right, I've reviewed the pre-sentence report and listened to counsel. Mr. Williams has declined to speak. I've considered all the provisions in 29, 29, 11, 12, 13, and 14. Clearly, Mr. Williams is not able to contain his apparent extreme anger with people, which has resulted in this offense in 23, the attempted murder in 24. As a juvenile, there's also a theft offense in 15, a robbery, felony robbery in 15, unauthorized use of a vehicle and criminal damaging in 15, receiving stolen property, felony 16. As an adult, attempted receiving in 18, attempted CCW in 20, and this felonious assault in 23, the attempted murder in 24. So you seem to have earned the right to be where you are. So in consideration of everything, I'm going to impose a sentence of a definite minimum of 4 years up to an indefinite maximum of 6 years in prison. That sentence will be consecutive to your Cuyahoga County sentence. And consecutive sentences are necessary to protect the public from you in future crime and for appropriate punishment. They are not disproportionate to the seriousness of your conduct in this case and the danger that you pose to the public. And clearly, your history of criminal conduct demonstrates that this sentence is necessary to protect the public from future crime by you. When you get out, depending on which sentence comes first and which sentence comes second, you will be on post-release control for at least 18 months, up to 3 years under the parole authority with conditions. If you violate, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If your violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which is the greater of 12 months or the time you have left under post-release control. The costs are assessed. Anything else, Mr. Gretzky?
Yes, Your Honor, the Reagan-Tokes advisements for this sentence.
Well, when you get you've got a definite minimum of 4 years up to an indefinite maximum of 6 years, and whether you serve any time beyond that 4 years is up to the criteria established by the Department of Corrections. So it's up to you how you behave in the institution. Anything else, Mr. Langmack?
Anything else, Your Honor?